Hello, this is attorney Russell Kohn of the Kohn Law Office with another installment of the Wide World of Torts. And today's topic is going to be how to settle a personal injury case. Every client and every injury victim wants to know how and when they can get their money for their injury. Now, this topic could take 3 hours for a seminar. There's so much involved with settlements, and I've attended many of those seminars. But I'm going to today distill it down to just a brief introduction as to the when and how to settle an injury case. So here you go. So first, we want to talk about pre-litigation settlements. Once you've got a prognosis for your injury, we call it maximum medical improvement, and you know your future treatment needs and costs, the client can then initiate settlement discussions by submitting a written demand to the insurance company for an amount high enough to leave room for a negotiation down to a satisfactory settlement amount. The written settlement demand should include an itemization of past economic damages, such as past medical expenses, not just co-pays, but the entire medical billings, and past lost earnings. And it should also include an estimate of future treatment expenses and expected future loss of earnings. There may be other categories of economic damages in any specific case. If so, include them too. The written demand for settlement should also include what we call non-economic damages, which is usually the largest part of damages in a personal injury case. And that can include the impact on a victim's lifestyle or their activities of daily living. And it can include scarring and disfigurement. So we recommend that the demand have attachments including photographs of any injuries, including the scarring, and it also must include the medical records and billings. Now, realize that non-economic damages include more than just pain. It also includes mental and emotional distress, inconvenience, disability, and impairment. So in the written settlement demand, you're going to want a few paragraphs discussing those particular items. The last paragraph of any good settlement demand letter should include an amount at which the injury victim is willing to settle his case. And usually that'll ask for the policy limits if those are less than the demand amount. And also include a firm date as to which the insurance company is to respond to the demand. And you can threaten a lawsuit if there's no response by that time deadline. Now let's talk about settlements after filing a lawsuit. Usually a lawsuit is filed if there's an inability to reach a mutually agreeable settlement before a lawsuit, or the statute of limitations date comes up before being able to get a full prognosis and the client is not at maximum medical improvement and still treating. In that case, you don't know the future damages, and thus you're unable to really engage in settlement talks, so you have to file a lawsuit. So after a lawsuit, there's 3 ways to settle a case. The first way is to submit a written demand, the same as you would do before a lawsuit. Before doing that, though, you should first formally ask for confirmation of the policy limit using the discovery procedures available. If that doesn't work, the second option is a mediation. And that's where a agreed upon neutral retired judge or experienced personal injury attorney gets in the middle and is able to determine whether or not the sides can settle the case short of a trial. Usually, in our experience, that's the best opportunity to settle the case before incurring a lot of expenses for a trial. A third method of getting a settlement in a personal injury case after a lawsuit is filed is the use of a CCP 998 offer in California. CCP stands for the Code of Civil Procedure. We use shorthand 998 offers. What this means is it's a formal offer that if you don't accept it within 30 days, then you do better at trial. You can get a lot more costs recovered than you could otherwise. Those costs include expert witness fees, which can amount to thousands of dollars. You should definitely consider sending one of these 998 offers early in the case before incurring a lot of expert witness costs. However, if you receive one of these 998 offers from the other side, you need to be cautious, because if you don't do better than the 998 offer that you receive, you could be liable for a lot of the other side's expert witness costs. And those could amount to tens of thousands of dollars. You want to consider carefully the 998 offer before sending one and when receiving one, because you don't want to refuse to accept one carelessly. Recently, we had a case where somebody received a 998 offer and did not accept it. And after their case went forward, they did not do better. And now the other side's insurance company is coming after them for $40,000 of expert witness costs. So we're trying to figure out how to get them out of that predicament. It's not easy. I was not the attorney on the case. They came to me afterward, but that's an important settlement tool in California that needs to be carefully looked at before accepting or rejecting an offer. The third thing we should talk about regarding settlements is that settlements must account for the liens and reimbursement rights of the injured claimant's own medical providers and also their health insurance companies, which may have paid for their treatment. And that includes HMO providers that actually provide treatment but don't actually pay for the treatment, such as Kaiser Permanente. Hospitals may have statutorily permitted liens in California upon the settlement, and other healthcare providers may also have contractually granted liens. Liens and reimbursement rights on personal injury cases is a very complex area of personal injury law. Attorneys try to maximize reductions of such liens and reimbursement claims to net as much of the settlement as possible for the injured client. If you have a large damages claim, you're likely going to fare much better with an experienced and aggressive personal injury lawyer who knows how to reduce those liens and reimbursement claims on any settlement. Settling a personal injury claim is an art, and it requires an experience and negotiating skills, and also knowledge of the laws impacting settlements. A lot of claims might need special needs trusts to preserve government benefit eligibility. If a child is injured, you might want to consider a structured settlement and also a blocked account. If Medicare is involved for an elderly client, you might want to consider a set-aside account so that Medicare benefits can be preserved. That's why this topic may require more than just a 5-minute conversation. So this was a brief discussion about how to settle a personal injury case. It's a very complex topic, and if you want further information about it, feel free to contact our office. We will definitely give you a free consultation concerning your case and any settlement possibility on it. Feel free to give us a call anytime, 760-721-8182, and we'll try to answer whatever questions you may have regarding settlement of a personal injury case. Thank you.